Hello, everyone. Thank you for joining us today for the New Mexico Department of Workforce Solutions Employer Webinar Series. Today, our topic is going to be the Healthy Workplaces Act. And to kick us off for this particular session is our Labor Relations Division Director, Tanya Kelly. As we continue through this, I just want to preface that if you have questions, please put them in the Q&A that's at the bottom of your screen. So that's where we will be pulling questions from. If we can't get to everyone's questions, we will follow up with adding to our FAQs on our website. And I'll be putting all that information into the chat that you can see. But for questions, please put them into the Q&A. And without further ado, Tanya, it's up to you.
Good afternoon, everybody. This is the first webinar I've been able to introduce as the director, and I'm really excited to be here. I joined in December, and I'm very excited to begin working with you. So please take this as the beginning of a conversation. My division, Labor Relations, has 5 units within it. They are the Child Labor Unit, Human Rights Bureau, Paid Sick Leave, Public Works, and Wage and Hour. So we deal with a whole bunch of areas to make sure that people are being compliant with the law. And we're really excited to start working with all of you in terms of answering questions, providing support, and going forward. For this webinar series, we're very excited to start with the Healthy Workplaces Act and discuss more about paid sick leave. I am very excited to have my colleague Rose Gonzalez join me today. She's going to lead the presentation as she is our resident expert on going through the Healthy Workplaces Act. We'll go through this. Make sure, as you were saying, Stacy said at the beginning introduction here, please put questions into the Q&A as we go. If there's anything that we need to address as we go forward in the presentation, we'll do so. And anything else we can do afterwards. But we're very excited to speak with you and learn more. And without further ado, here is Rose.
Hello, everybody. Thank you so much for joining us today. My name is Rose Gonzalez. I am one of the team members here with the Labor Relations Division. I'm going to go ahead and begin this presentation. And as Stacy and Tanya both pointed out, if you have any questions, I'm more than happy to pause in between slides and answer those questions. Any one of us can do that for you. So without further delay, I would like to welcome everybody again to, can everybody see my screen? Tanya, Stacy?
Yes, your screen looks great.
Thank you. So again, we are the Labor Relations Division, which is part of the New Mexico Department of Workforce Solutions. And today we'll be covering employer compliance and New Mexico Healthy Workplaces Act, what you need to know. I would like to point out that this is not intended to be all encompassing. We do understand that you may still have additional questions, and Stacy will be, as she mentioned, not only helping with the questions in the Q&A, but also towards the end, if she has not already done so, we'll be putting our contact information if you have other questions that go beyond our time here today. So the big picture of the Healthy Workplaces Act or the Paid Sick Leave Law, those are interchangeable. The Healthy Workplaces Act is very simply the official or legal name of the statute, or better known as the New Mexico Paid Sick Leave Law. It was enacted on July 1st of 2022. So we're coming up on 3 years that this law has been in effect. The big picture is this act or this law requires all private employers, regardless of size, to allow employees to earn and use paid sick leave. So basically what that means, it doesn't matter what size your organization is, whether you are a small mom and pop organization, or if you're corporate, if you are a private employer, all of the employees should be allowed or should have already commenced being allowed to get paid sick leave as of July 1st of 2022. Employees need to be allowed to accrue. There's 2 forms of accrual with which employers are allowed to give out paid sick leave. One is accrual and the other is front loading. So if as an employer you are opting to use the accrual method, employees should earn 1 hour paid sick leave for every 30 hours worked throughout the year. One of the things about this is it does provide a gradual accumulation, and it does align with actual hours worked. So for example, let's say you have an employee who works 60 hours a week. They're not going to get time and a half accrual for paid sick leave under this option. It'll be a straight 1 hour for every 30 hours worked. So in the example I just gave, it'll be 2 hours for the 60 hours they worked in that week. The other thing that I would like to know is it doesn't matter what the employee's employment status is, basically meaning it doesn't matter if they're full-time, part-time, per diem. Everybody should be allowed to accrue sick leave or have it front-loaded. Alternatively, or in addition to rather, immigration status is not a factor when considering the paid sick leave law. It doesn't matter what the immigration status is of the employee. If they are working in the state of New Mexico, they need to be allowed to be either accruing or be getting paid sick leave front-loaded. So in the alternative, front-loading would allow or enable employees to receive 64 hours of paid sick leave on January 1st of each year in one lump sum. If an employee, if you have the front-loading option and you are choosing, or I'm sorry, if somebody's hired after the first of the year, the law does allow for prorating of that 64 hours if they are hired after January 1st of each year. One of the options under the front loading, it does ensure that it ensures immediate access to employees as soon as they are hired on January 1st, that they'll have this lump sum of 64 hours to use. Again, as I mentioned a moment ago, you can make adjustments for new hires if they're hired after January 1st. The thing with the front loading, if you have a part-time employee or an employee that may be, not part-time, excuse me, but an employee that may be on the cusp of working 1,920 hours or more, you would need to really pay attention to your tracking mechanisms in regard to paid sick leave, because if they're working more than 1,920 hours in a year or more than 40 hours a week consistently throughout the year, they will be allowed, or need to be allowed, excuse me, to be front loaded or given more than 64 hours in a year. If anybody has a question in regard to this slide.
There were two questions that came up,
okay,
Rose, that I can address, or I would like
okay,
you to address.
Yes.
And I am seeing great questions in the Q&A coming through. So we will definitely need to get more into the details afterwards. One
Okay.
question, however, was, does this apply to private industry or government industry or both for employees?
So it is private employers. So
Private.
the state of New Mexico does not have jurisdiction over other government entities, as well as we do not have jurisdiction over tribal entities.
Wonderful. The second question for this slide was, what if someone's budget year is a fiscal year that does not start in January? Can they still front load? Can they use a front load option if, say, their fiscal started in July rather than January?
You can use the front load option. However, it must be given on January 1st of each year.
Okay. All right, let's move on.
So there are several purposes under which sick leave can and is permissible for use. I do have a note here that this list here on the screen is not all inclusive, but is many of the more common reasons as to why people would be asking for paid sick leave. So it's going to be for the diagnosis, care, treatment of a mental or physical illness, injury, or other medical condition of the employee and the employee's family member for the same reasons. Also, the act does allow for family members that are not necessarily quote unquote blood relatives. So if you have somebody that you're caring for on a regular and consistent basis, and they need help getting to the doctor or whatever the case may be, the act does cover, I guess, family members that are family members by proxy, if you will. Also, this act does allow for preventative medical care for employees and their family members. So I know that historically or traditionally, employers would, they let people just either take off for a couple of hours and then come back for their sick leave. This would cover the 2 hours. And in addition to that, employers are not, under the law, should not ask for or require documentation for any time taken that is less than 2 days. So for 2 days or more, employers can ask for documentation. Anything less than that, we do need to allow the employee to utilize the paid sick leave and get paid for those doctor's appointment, dentist appointment. Also, this does cover meetings at children's school or places of care related to the child's health or disability. Also, this act does cover absences related to domestic abuse, sexual assault, or stalking suffered by an employee or their family member. The act also, if one of these unfortunate situations were to occur, the act also covers if an employee or whoever suffered any one of these items that I just listed. It would allow them to even time to move if they needed to relocate because of something related to domestic abuse, to go to court hearings, file documentation, or again, to seek treatment or care because or relating to a domestic abuse of any kind. Employers, so this goes back to the accumulated, unused, or bank hours. Employers are not required to pay employees for any banked hours of sick leave upon termination, resignation, retirement, or for any other reason that an employee separates employment, unless paid sick leave hours are combined with PTO. There have been many instances, and some employers, who combine PTO with sick leave. Employers are allowed to call these hours whatever, pretty much whatever they want. PTO, some people call it time off, paid time off, sick leave, but the employer allows employees to use these hours for any purpose that the employee is selecting or asking to use them for. So for example, if I'm sick or if I want to go on vacation. If you have this combined bank option, however, please be mindful of the fact that you may be subject to having to pay the combined bank out upon termination, separation, or resignation. That is a completely, separate, those are two entirely separate things, where again, I'm just going to repeat, if it's a separate bank of just sick leave, your employers are not required to pay that out. But if it's a combined bank of paid sick leave and PTO, employers may be subject to paying that out upon an employee's separation or termination or whatever other reason they separate from the employer. This is a very amended training on the Paid Sick Leave Healthy Workplaces Act. Also, it was intentional to open up now for any kind of questions. Do want to let you know that if you have any additional questions, we do have separate trainings once a month. They are right now primarily done via Teams. They are in person, just like this one, or I'm sorry, well, over Teams in person. And if you are interested in having other managers, HR, accounting, payroll, anybody in any type of leadership position, attend one of these trainings, you can reach out to us on the number on the screen or at our admin, sickleave.admin@dws.nm.gov email account, and somebody will reach out to you to get you scheduled for one of those trainings. I'm going to go ahead. This is a conclusion of the slide portion of it. So we're going to go ahead and open this up for any questions that any employers might have in regard to paid sick leave. And again, I do want to mention this presentation today, this webinar, it is an amended version. So again, if you'd like to have further or additional training, or if you have additional questions beyond today, our contact information is on the screen.
And quick note from everyone, we are going to provide a recording of this presentation to everyone who is registered for this event, including the question and answer section. So you will get access to this to review in the future. And then you also have our contact information.
Perfect. So I think we will get started and ask a couple of questions that are coming in. We're going to kind of jump around. But the first question I have here is, do 1099 employees get paid PTO?
I'm sorry, you kind of cut out. You did say
Sorry.
1099, so independent contractors.
Yes.
So that question, quite honestly, is a little convoluted. So we need to ensure, first of all, that they are actual 1099 or contract employees. If it's, a solid, they are an independent contractor, I just hire them, or they come on board every once in a while, they have their own business, then in that kind of scenario, they would not need to be given paid sick leave by the employer. However, if you have, and I'll give an example, if I have my own housekeeping business and I'm consistently and regularly going to your house, and you dictate the hours that I work, the schedule, whatever days and times that I'm there, then at that point, the employer would be subject to paying out or allowing for that employee, not paying out, excuse me, allowing that employee to accrue sick leave, or in the alternative, front load it to them.
Thank you. The next question is, what are the maximum paid sick leave hours per year?
That's a great question. So there's a couple of different responses to that. They kind of end at the same, they have kind of the same ending. So the max amount of hours that employers need to allow employees to use would be 64 hours a year. That would be the max. Again, in the example that I gave earlier, if you have an employee who is just working a crazy amount of overtime hours, you're going to want to make sure that you are keeping track of that, because while employers, and this is a little bit of a pain point, I guess, if you will, for employers sometimes, but if you have somebody working a lot of hours, they're crazy overtime, whatever the case may be, and they're accruing more than 64 hours, employers still do not have to allow more than 64 hours to be used in a year, even though an employee sees that additional time on their time card or on the app, or whatever way you're disseminating their balances to them. Additionally, I'm going to give another example. Let's say I'm the greatest, most fascinating employee in the whole wide world. I never call in sick. You hired me on January 1st, and on January 1st, you gave me 64 hours. I did not call in at all that year. The following year, and this is in a front load scenario. So the following year comes January 1st again, you will be giving me another 64 hours. So yes, I would have 128 hours of sick leave into that second year if I do not ever call in. However, the employer still does not have to allow me to use more than 64 hours in that year. Coming into year 3, I'm still the best, most amazing employee ever on the planet. I don't use any hours that second year. So going into year number 3, I would get another 64 hours on January 1st. However, at this point, you only have to allow me to carry over 64 hours. I would still carry that 128-hour balance for the year. But again, and to repeat myself, you would not have to pay them more than 64 hours of sick leave in a year.
Thank you. The next question is, We use the front load option. What happens if an employee is terminated?
So I think to kind of reiterate, would you have to pay them out? Is that the question?
Yes.
So if it's a single bank and you're only giving paid sick leave and it's not combined with PTO, then employers do not have to pay them out. Sorry, I was trying to get something out. My voice is talking faster than my brain. What we would divert to, or I'm sorry, revert back to, if a complaint was filed that that sick leave was not paid out, is that we would request to take a look at your attendance policy or the paid sick leave policy to see how you're disseminating that and how you're allowing them to use it, because that's going to be a huge factor. You can call it sick leave, but if you're allowing them to use this sick leave bank for vacation or for any covered purposes under the Healthy Workplaces Act, then you may be subject to paying them out. However, again, if it's just the paid sick leave, it's just sick leave, they're only using it for sick leave, then you would not be required as an employer to pay them out any balances upon termination, separation, resignation, or for any other reason.
Thank you. The next question is, do remaining hours carry over to the next year?
Yes, and so employers, if they have, whether it's in the accrual method or in the front load method, employers need to allow employees to roll over a minimum of 64 hours. So of course, if they have 5 hours left at the end of the year, they need to be allowed to roll over that 5 hours. If they have 60 hours, they need to be allowed to roll over the 60 hours.
Are there any changes to the Act from the original implementation?
As of yet, there have not been any amendments to the Act upon its implementation on January 1st of 2022.
For school districts, does this pertain to substitutes?
If it is an APS or government-funded school, the state of New Mexico would not have jurisdiction over them. So basically what that means is that, hopefully they're still giving you the paid sick leave, but if there was a complaint that was sent to us, it's the state can't investigate the state, or the state can investigate federal. We can't investigate another government entity.
On the accrual basis, can you just reiterate about the 64 hours? So is there only a maximum of 64 hours per year that an employee can use, or can they accrue more?
That is a very good question. So under the accrual method only, employers are not allowed to ever cap or stop accruals. It does not matter if they never use them, or in my example of the best, most amazing employee, they don't use them in a couple of years. Under the accrual method, employers should never stop or cap accruals. However, as in the front loading example, employers do not have to allow employees to use more than 64 hours in a year.
If an employee is only part-time, do they also get the 64 hours a year?
That is going to be a decision that the employer makes. That's not something that the state of New Mexico would dictate. However, employees, whether they are part-time, full-time, per diem, they would need to be allowed to either accrue or be front-loaded paid sick leave hours.
A few questions are coming through asking if this leave can be used for bereavement or for funerals.
As a standardized response, not necessarily. However, it just depends if you had a POA or a power of attorney over, the parent or, the family member or whatever, and you were needing to get their affairs in order, something like that, then that would be up to the employer. But in a situation like that, then I believe I shouldn't say I believe, it would be a valid reason to use paid sick leave. If it's just because, and I'm not trying to minimize or anything by any means. However, if it's just it's to go to my friend's funeral who her cousin passed away, then that would not be a covered reason under the Healthy Workplaces Act.
You said that the employer can ask for documentation for an employee that takes 2 days or more of sick time. Is this optional or is this mandatory under the law?
So employers are allowed to request the documentation after 2 or more days. That is and does seem to be standard process and procedure based on my experience and the investigations that I have done. If you decide to go ahead and make it mandatory, I mean, make sure that it's very clearly defined in your policies. The other thing is that if you decide to make this, as you called it, mandatory, employees do have 14 days in which they could provide the documentation. So if I'm out for 2 days, you ask me for a doctor's note, and I don't give it to you within the first few days, I cannot be, penalized in any way for that. I need to be allowed up to 14 days to provide that documentation. And even if I don't provide that documentation in the 14 days, I still need to be paid for the sick time off. So just because I don't provide the documentation, I still need to be paid for the sick leave. However, in the alternative, if the doctor's note is not provided in the 14 days, then after that time, then you could potentially, have a conversation with the employee about violating that portion of the act where they didn't provide the documentation, but you cannot penalize them or have any kind of conversation in regard to the actual use of the sick leave.
Can employees use it for mental health day?
So the short answer is yes, because I'm not a doctor. I don't believe, unless you're a doctor for a medical institution, we wouldn't be able to determine as employers who actually needs the mental health day and what that looks like. If I'm calling in and saying, I really need this day, I need a mental health day, then we would be inclined to go ahead and pay that.
If a company is based in another state, but they have a remote worker in New Mexico, do these policies still apply?
That's a really great question. So if the employee is doing actual work in the state of New Mexico for New Mexico, then they should be allowed to accrue paid sick leave or be front loaded. However, if my home base is in New York and that's where my company is, I do no work in the state of New Mexico, but I do live here and I'm doing remote work here, then the employer is not required to pay sick leave in that situation.
Is the 1 hour sick leave for 30 hours worked also required to be accounted for the overtime hours?
So yes, but it wouldn't be time and a half, if that makes sense. So even if they're overtime hours, we pay wages at time and a half for any overtime. But with the sick leave or the Healthy Workplaces Act, it's considered, it would be paid out as straight time, if you will. So again, if I work 60 hours in a week, I should be allowed to get the 2 hours in an accrual situation.
If an employee doesn't use all of their accrued sick leave, is the employer allowed to remove the unused hours?
No.
Great. I wasn't prepared for the next question. You answered that so fast. Okay.
Yeah, you can't remove, take away, deduct any hours at all. They just need to continuously be allowed to accrue or just maintained in a front loading situation.
How does paid sick leave apply to salary employees?
That's a great question. The short answer is yes, it does. I do understand that in the state of New Mexico, salaried employees, and again, we're going to revert or look at the employer's actual policy. However, for tracking purposes, and if this ever comes up for any reason and a complaint is filed against the employer, they should be able to show that they did track or did allow to use or did code in their payroll system that it was actual sick leave that was used. So for example, let's say I'm a salaried employee, I'm making $1,000 a week. I call out on Friday, then you would take my salary at $1,000 a week divided by 40, and whatever the 8 hours is, I think it comes out to, I don't know exactly, I don't have my calculator in front of me, but either way, so you would still pay me because I am a salaried employee, but you would code that additional 8 hours as PTO, as paid sick leave. So in a salaried situation, really the only thing that changes is the way that you're coding it, because again, this is going to assist the employer in staying in compliance with the law, because you're showing that you were tracking paid sick leave use, which is required under the Healthy Workplaces Act. Employers need to be able to show, if there's ever a complaint filed against them, they need to be able to show that they had the balances, the accruals and usage, and that all of this was being tracked and maintained.
Can an employer combine vacation and sick pay as one bucket?
Yes, they can.
And Rose, one question that I've seen from several companies is, I have X many of hours of combined paid sick leave and annual leave. Is there any sort of standard for if someone has just a general leave bucket, what would be in compliance or out of compliance with that?
It all comes down to the employer's policy. What does the policy say? What are they allowing the employees to use the leave for? Do they have distinct and separate things or situations or scenarios that they're allowing them to use? If it's just a general bucket and we have a complaint filed against that employer for the general bucket, we're going to always look back at the policy and what the policy says. So employers are allowed to have a general bucket. They're allowed to have one bucket, they're allowed to have two buckets, and they can actually call it, again, paid sick leave, they can call it PTO, they can call it whatever they want, as long as they are in compliance with the Healthy Workplaces Act and everything that it encompasses within the law.
Are employers required to pay out PTO if an employee is terminated for cause?
If the PTO is part of the wages earned, then they would be subject to paying them out. And so what I mean by that, if they are getting or being given, or the employee is accruing PTO and it's based on the hours worked, then they need to be paid that out. Even if it's for cause, yes.
On the opposite end of that, how does the accumulated hours from previous time employed carry over when rehired?
That's an excellent question. So employers need to reinstate any paid sick leave back to the employee if they are hired within 12 months. So if you hire me back within 12 months, then I need to have whatever bank I had left over, that has to be reinstated back to me. If it's 12 months and 1 day, then it wouldn't have to be reinstated to me. Also, to kind of piggyback off that, if an employer sells the company to their friend, they need to really figure out how that's going to work on a contractual basis. Is the previous employer going to pay that out, and then the new employer can allow the paid sick leave to carry over? Or are they going to make it part of their contract and it'll just carry over, and then the new employer will just continue on with whatever bank they had?
Is a job protected? Oh, sorry, go ahead.
No, no, you're okay.
Okay. Is a job protected under the New Mexico paid sick leave the same as it would be under FMLA?
No. FMLA is a federal program. It is unpaid program unless, of course, and again, the employer, has certain criteria or stipulation, or the employer allows that. Paid sick leave is separate from that. There are many employees that I have experienced that do allow for their employees that have accrued sick leave to use the paid sick leave that they have in their banks when they take FMLA. However, those are two separate things. FMLA is federal. The Healthy Workplaces Act or New Mexico sick leave law is state.
What if paying sick leave would bankrupt a small business?
We understand that there's a lot of scenarios that just are, difficult for small employers, and we are here to help, assist the small businesses in any way that we can. We have many different units or divisions or departments. We have a lot of resources in which we can help the small businesses manage that, or give them guidance and assist with information on how to prevent that from happening. So if you have any questions in regard to any of that, we're truly here to help, assist, empower, and educate. We don't want to see anybody go bankrupt or be put out of business because of this law. This is part of the reason why we are having these educational series.
Can you have both a front load policy for salaried employees and an accrual method for hourly and part-time employees?
Yes, you can. Just make sure that it's clearly outlined in your policies.
Let's go to this one. Can you choose to not pay out of the bank of sick leave to one employee, but not another?
No, that could be considered discrimination. It could also be considered retaliatory. I'm not really sure under what circumstances you would want to do that. So I would err on the side of caution and not do that.
If an employer accrues more than 64 hours a year, can the employer cap the usage at 64 hours?
Yes, that is written in the law that employers do not, even if an employee has more than 64 hours, employers do not have to pay more than 64 hours in a year. The year can be a dedicated year. You can start the actual tracking, if you will, of the paid sick leave, like at an anniversary day, or maybe the first time that they actually used it. But whatever that year for tracking purposes only is, just make sure that it's consistent for all employees across the board.
What is defined as work for New Mexico? For example, is contributing to a New Mexico branch for an out-of-state company the same as work for New Mexico?
I have no idea what that is.
Tanya, do you
Tanya,
want to jump in on that one?
work for New Mexico? I'm
So
not.
I think that might be whoever asked this question, if you're on the Q&A, let me see if I'm interpreting it and let me know if I'm saying it correctly. Let's say we'll pretend it's a national franchise, but there is a branch location in New Mexico.
Is that the correct interpretation? Did Tanya give the correct interpretation of the question?
Yes, that's correct. Yes.
Okay. So if work is being done in the state of New Mexico, employees need to be allowed to accrue sick leave or be front-loaded sick leave. So it doesn't matter if it's a national franchise. It doesn't even matter if it's an international franchise in the state of New Mexico. If the work is being done and performed here, then the employees must be allowed to accrue or be front-loaded sick leave.
Is the reason required to use sick leave?
I'm sorry, can you repeat that?
Or is it required to have a reason to use your sick leave?
No. Employers are not allowed to ask the reason for sick leave. One of the examples that I like to give is if you know unequivocally without a doubt, and there's like maybe one or two reasons why you could actually deny it, and you would have to have unequivocal without a doubt proof. So for example, if I told my boss, I am just so deathly ill and I need to call in and I need to use sick leave, and then they see me out dancing at the fiestas on a work day, then and somebody is privy to that and you have unequivocal truth or proof of that, which nowadays in the day and age of social media is very possible, right? Then an employer could potentially deny it in that situation or in that scenario. But other than that, an employer can't ask, like, why are you sick, unless an employee voluntarily gives that information.
Does this apply to a family business with only one outside of a family employee? So one outside employee from the family who is part-time.
Yes. They would still need to be allowed to accrue it.
Can you explain how the rollover is handled?
So you're just allowing the rollover to carry over into the next year. So for example, I have 64 hours that was front loaded to me on January 1st. I use 34 of those hours, which would leave me 30 hours at the end of the year. I need to be allowed to carry that over into the next year, and it needs to be clearly documented either on a check stub or some kind of quarterly notification. At minimum, employers must give notification to employees of their balances, accruals, and usage at a minimum of once per quarter. If that information is on their check stubs already, then you're good to go. You're doing, you're giving them that notification. But in that scenario, they're going to need to be allowed to just carry over the 30 hours if they have whatever balance they have that is 64 hours or less. And then the employer needs to allow for that to continue to carry on throughout the next year, if it's accrued or front loaded on January 1st in a front loading scenario.
What can be done about the abuse of sick leave? Example, taking every Friday and Monday and not bringing in doctor's notes.
So after a certain amount of time, right, if I'm calling out every single Friday and I'm going to use the accrual method, for example, I'm getting 1 hour for every 30 hours worked eventually, and I'm calling out every single Friday, I'm eventually going to run out of time. I'm going to run out of sick leave. Any time that I do have under the Healthy Workplaces Act, or any sick leave that I actually do have, is protected time. You want to consider it just protected time. So let's say I work an 8-hour shift. I call out on Friday, but I only have 5 hours of sick leave left. That 5 hours, I cannot be penalized. I can't be given a coaching or counseling or anything to that effect. However, the 3 hours remaining, that's not protected time. And an employer technically could, bring that to the employee's attention. Hey, you're running out of time, or you ran out of time. This wasn't protected time. It can be addressed. An employer just needs to be very careful on how they do that. Because also, if they have a pattern or a history of, it's every single Friday, then as long as it's not in a retaliatory manner, the employer can address the attendance issues in and of themselves. You can't penalize or give an employee a coaching for any protected time, which would be time that they actually have.
If a company has a remote employee that lives in another state outside of New Mexico, are they covered under the New Mexico sick leave or their state of residence sick leave? Which one prevails?
Wherever the work is being done, where is the work actually being done and being performed? So again, in the remote scenario, I'm working here, but as a remote employee, because I live in New Mexico, but all my work is being done in New York, all my clients are in New York, all my vendors are in New York, then there's no work being actually performed here. I just live here, so I obviously have to work here. So it would be covered underneath the other state's sick leave policy. If I'm a remote worker in another state, but all my contractors are here, my vendors are here, my work is being done and it's affecting work and how it's done in the state of New Mexico, then I need to be covered under the Healthy Workplaces Act.
What are the circumstances where paid sick leave combined with PTO would need to be paid out?
We're gonna always take a look at the employer's policy, but if an employer is combining sick leave with PTO, more often than not, unless it's a very rare situation, the employer will be subject to paying out the PTO upon termination, resignation, because it's based on hours worked. PTO, for the most part, is accrued based on the number of hours I work. So, for example, just going back to our 1 hour for every 30 hours worked, I'm getting PTO because it's associated with the number of hours I'm actually working, which is considered wages at that point. And so upon termination or separation, I would need to be paid out the PTO balance. As a standalone law, if we're looking just at the New Mexico Healthy Workplaces Act or the paid sick leave law, just in and of itself, it is written into the law that employers are not required to pay out the sick leave upon resignation, termination, separation for any reason. Employers don't have to pay it out unless it's combined with PTO. We are going to go back and take a look at those PTO and sick leave policies if a complaint is filed against the employer for violation of the Healthy Workplaces Act. And quite honestly, at the end of the day, the employer's policies is going to determine which direction we're going to go.
If an employee calls in sick, can the employer automatically apply their sick hours to payroll?
If that's the only bank they have, and more often than not, unless an employee explicitly states that they don't want their paid sick leave used, they don't have to pay that out. But as an automatic general rule, you're going to want to go ahead and make sure you're letting them know or informing them, because at that point they need to be given the option if they want it paid out or not. Now, a little kind of nuance to that is if the employee decides that they do not want to have paid sick leave paid out, and I'm talking about just the paid sick leave bank only. If an employee decides that they don't want the paid sick leave paid out, then they are not going to be covered under the Healthy Workplaces Act because there's nothing to protect them because they're not using paid sick leave.
You accrue sick leave on PTO hours.
Paid sick leave is it's a completely separate law than PTO unless the employer chooses to combine those banks via their policy.
You explain what protections the employer has against employees abusing the law.
I would say documentation. Just make sure that you have thorough and complete documentation in regard to when they're out. That's why it's so important, the tracking and the documenting of the paid sick leave, how many hours they're working, how much time they're accruing, or if they're front loaded. The documentation is super important. The employee files and just documenting whether they're habitually using this, if there's any kind of strange things going on where you feel like that it's being abused, then you can absolutely address that. Again, it's going to go back to or revert back to whether or not they have the time. If they don't have any more time, employers are not required to keep perpetually paying out sick leave if they don't have the time. At that point, the employer can adhere to whatever their internal corrective action policies are in regard to attendance or the abuse of sick leave if they are in fact abusing it. But again, you want to make sure that you're documenting it, because you want to make sure that you're steering clear of anything that could be construed of as retaliation or anything like that because the employee used sick leave. But you can definitely, you know, as long as you're documenting it properly, if an employee is habitually abusing or using the sick leave, at some point in time, they're going to run out of time. They're not perpetually covered under the Healthy Workplaces Act unless they have the time.
Was there an amendment passed to this law? And if so, what was it?
There has not been an amendment passed to this law as of yet.
Must an employer wait 2 days or 16 hours before asking for documentation? Or may
Yes.
employers ask for documentation after the first day or 8 hours?
Employers can only ask for documentation if an employee's been out for 2 or more consecutive days.
Are companies capped at the 64 hours of sick leave, or are they supposed to give more if they accrue more?
So the 64 hours is a baseline. Employers, that is the minimum amount that should be given if you're choosing a front load option on January 1st. If it's accrued, excuse me, it shouldn't, an employer cannot stop or cap the accruals. Like, it has to keep accruing, but they don't need to allow an employee to use more than 64 hours in a year.
Does an employer have to roll over the accrual balance of sick leave hours from calendar year to calendar year, or just 64 hours? This particular employer uses the accrual method and limits the use to 64 hours, January through December.
So if they have more than 64 hours, then they only, at the end of the year, on December 31st into January 1st, they only need to roll over the 64 hours. If they have 5 hours, they should roll over the 5 hours. They need to roll over the 5 hours per the law. If it's any more than 64, then only the 64 is the only amount that needs to be rolled over.
The next question is, we've been using the accrual method. Can we switch to front loading at the beginning of next year where everyone starts with a 64-hour balance?
You can do that. Just make sure that you're giving your employees plenty of notification. Let them know what you're doing. You have to notify them in advance of the plans to change it.
How is sick leave accrual calculated for those who work more than 40 hours per week, or 1,920 hours per year?
It's still always going to be accrued at the 1 hour for every 30 hours worked. So whatever amount of hours they're working in a week, you're just, any number that they're working in a week or 2 weeks, whatever your payroll system or pay period is, you divide the number of hours worked by 30 hours, and that's how many hours of sick leave they should be accruing under the accrual method.
Do paid sick leave hours cover maternity leave or for pregnancy or related medical sick leave?
As a rule, yes, because for maternity leave, you're going to the doctor to get checked. You're gonna have to care for the infant or the child. They're gonna have to go get checked. So as a rule of thumb, if they have the available time, it is for their own personal care or for the care of a family member, then they should be paid for that if they have the time.
The 2 consecutive days that include if an employee is scheduled for work Monday, off Tuesday, scheduled for Wednesday, and off Thursday, are Monday and Wednesday consecutive?
Yes. They would be considered consecutive, and you can't ask for it at that point.
How do employers ensure employees are using paid sick leave for qualifying reasons? Do employers need to track the qualifying reasons?
So you can't ask why they're using sick leave. Um, if they let you know, then of course maybe you could document at that time, but you can't ask them why. So it's a little bit of a little bit of a pain point with employers. We understand. However, you can't ask them why unless they voluntarily give you that information. So just do the best that you can to document it. After the 2 or more consecutive days, you can ask for documentation. So I would just kind of just document, that they're out. And at some point, even just doing a check-in with employees can also help maybe open them up to maybe that there's other issues going on that the employer may be able to assist with.
Can you clarify the combined leave payout?
So in a combined bank situation, if you have paid sick leave, okay, this is one bank, and then you have PTO, and you're letting me use paid sick leave and PTO, and we're calling it PTO because I'm sick or my family member's sick, and for me to go on vacation, that's considered a combined bank. If you're allowing an employee to use sick leave in a combined bank situation and they get terminated or they resign, because it's PTO, and under PTO, it is considered, the accrual is considered wages earned because of the way that it's being earned. It's accrued based on the number of hours worked. They would need to be paid out in upon separation or termination. We're talking only in a combined bank situation. Now, if you are front loading, giving, or for lack of a better word, gifting, if you will, 64 hours on January 1st of each year, and you're just giving it to them, that is more than likely not subject to having to be paid out because it's not based on hours worked. It's what you're doing. It's a bank that you're giving one time at the beginning of the year, and then you're letting employees know that they can use it for any purpose under the Healthy Workplaces Act, or if they want to go on a trip to the Bahamas. We're always going to look back at your policy when considering, and if a complaint is filed with us, and when considering whether we should move forward with the investigation. It's always going to come back to the employer's policy. That's why it's always strongly suggested that you have good, strong, clear, and concise attendance, paid sick leave, or PTO policies, whatever you're choosing to call it, and however you're allowing employees to use it.
And Rose, I'm going to wrap up with this last question. What
Okay.
about agriculture or labor contractors?
If they're seasonal and you're continuing to hire me every year, even if I'm seasonal, that's basically me coming back before a 12-month period has expired, then I need to be allowed to accrue that sick leave.
That is fabulous.
The only entities that are not covered are, we have no jurisdiction over tribal government, so any federal, state, local entities, we do not have jurisdiction over them. That does include like APS, some colleges, any institution or organization that gets government funding, we do not have jurisdiction over, as well as tribal.
Thank you so much, Rose. And everyone, thank you so much for the questions. They were really diverse. They were really fun. And Rose, I really enjoyed how fast you're able to answer all these questions on different topics. I am so excited that I'm getting a chance to learn from all of you and learn from Rose through these questions. I really appreciate that we're really being proactive here. As a quick recap of what's going to happen, we are going to be providing a recording of this training to everyone, and that includes our contact information. I am sure that there are some questions in here that we weren't able to get to, even though we definitely want to. Please make sure that you're comfortable sending us questions. We have our email that is available in this recording and was on the screen during the Q&A session. You can also give us a call. If there's anything that you're interested in about getting additional trainings for your organization, we can make sure that we're going through all of those, and we can provide trainings for your organization or have people from your organization join us. Thank you so much. I know that we're seeing we got quite a few questions coming in. And so I really want to make sure that as we tried to get to everything that we could, but we weren't able to get to every question because of the volume. So if you have something that you didn't get addressed, please send us an email, because we want to make sure we're helping wherever we can to provide support. With that, this concludes our presentation. Thank you so much for being here, and I'm really excited to continue to work with you. Have a great rest of your day.
Thanks, everybody. Bye.
Bye.